Yes.
I take your lordship to RP number 797 of 2025. 797 of 2025. Yes. My lord, court
These
is
are
free.
these are review petitions.
Yes. First, court is free to err within a jurisdiction. First principle of jurisprudence, my lord.
Counsel, confine your arguments to the ground raised in the writ petition.
I have not started.
Yes, yes.
Let me start.
Yes.
Then your lordship, I am going.
Yes.
Well, I am diverting to some other terrain. Your lordship
No,
can
no, no.
certainly guide me.
Yes.
Yes. I only started. My lord, the review will die.
First of all, address arguments keeping in mind that this is a review petition.
Yes, yes, my lord.
Yes.
My lord, I have been in the bar for pretty long time. Since 79, I have been in the courts. Pretty long time. I am appearing before the lordship.
Make your submission on the
very
point.
noble judge. Justice Narendra, I appeal before his
Yes,
lordship.
you can make your submissions. We are on the legal aspects.
Yes. So I have it. The faculty said about.
No, we don't require such a.
Four things belong to a judge.
You can make your submission so that because others are also waiting here. Why should you go on those aspects?
First is here courteously. Number one, a court is free to err within its jurisdiction.
Yes.
The concept of residuicata pro veritate accipitur means a judicial decision, right or wrong, if it is within its jurisdiction, it having observe the principles of natural justice, without it is not in conflict with the express statutory provisions, or if not conflict with the express well-settled legal principles, my lord is binding. Is binding between the parties. Residuicata pro veritate accipitur. Judicial decision has to be treated as truth. The judicial member pro veritate accipitur. A judicial decision is always to be treated as truth. For two simple reasons, which my lord Justice Nariman in his judgment in Canada Bank will be the judgment. My lord, start with Justice Nariman judgment. Start with Roma locuta est, nasa finita est. And I'm only quoting what Justice Nariman has quoted in his judgment in Canada Bank, in the first paragraph, where Justice Nariman has said, refer to two fundamental principles, fundamental Latin maxims. That is, interesto republico ut sit finit litium. It is in the interest of the republic that there is minority of litigation. And the more the bet vexari pro uno et ilum cosa, no man shall be vexed on the same question more than once. Therefore, my lord, the judicial decision has to be treated as truth.
Yes.
Via justitia ruat silum, via the authority of a cause shall be given effect to. And therefore, my lord, would be a Roman lawyer would be and says, Justificata facit ex albo nigrum, ex nigro album, ex recto garbum, ex garbo rectum. A judicial decision can make on fact, can make what was white black, what was black white, what was crook straight, what was straight crook. So therefore, I am not here on the premise that your lordships have said 1 plus 1 is 0. Your lordships have all power to, my lord, jurisdiction means, as is said in Ujjambai, para 15, jurisdiction means the jurisdiction to the authority to err and bind the parties by erroneous decision. So I am not complaining here that your lordships have said 1 plus 1 is 0. But God's attempt is always to avoid a scenario where it makes error on facts. Here, my lord, I am confined, I am agreed because, my lord, your lordships have a word on law. Your lordships, my lord, is duty bound to enforce law. And my lord, all of us are servants of law. Let's know it. The court always knows that that's a presumption, that there is no need to plead law. And my lord, the court is always to be governed by law. And the proposition which I brought about your lordship's most gracious consideration was, there is an enactment which the parliament has enacted, MSME Act, and the notification.
Where is your colleague?
I take your lordship to the notification. Because this is such an important issue. It is affecting not one Nastapan. It is affecting around 1 crore MSMEs. There is no issue which is more important than probably than for a common man is concerned than MSME doing notification. The legislation, which is the MSME Act, your lordship has the copy. The MSME Act is a reflection of a legislative intent of after deliberation for many years. The act was enacted. I take your lordship to the object clause. Only read one sentence from the object clause. Yes. I want to ask your lordship say I only read one sentence from the object clause. Page 1 number. Before page 1.
Okay.
Statement of objects and reasons. Small scale industry is at present defined by the notification date 11B of the Industries Development etc. Act of 1951. Section 29B of the Act provides for notifying reservations of items for exclusive manufacture in the small scale industry sector. Except for these two provisions, there exists no framework for this dynamic and vibrant sector of the country's economy. Then I am skipping all this, my lord. Now, para 2. In the aforesaid circumstances, the bill aims at facilitating the promotion and development and enhancing the competitiveness of small and medium enterprises, and seeks to provide a statutory definition of etc. Small enterprise etc. To provide for the establishment of a national board etc. Then, yes, thank you. Provide for classification of micros, small and medium enterprises on the basis etc. Then D. Empower the central government to notify programs, guidelines, instructions facilitating for the promotion, development and enhancement of etc. of the MSME. Then, my lord, I am skipping as much as I can. Yes. Then E. Make provisions for ensuring timely and smooth flow of credit into small and medium enterprise etc. Then, my lord, F. Empower the central and state governments to notify permanent policies etc. G. Empowering the central government to create fund etc. Then, my lord, therefore, this enactment is a legislative bill, and it is the legislature decided that MSME shall not be allowed to die. So it is a preventive legislation. My lord, then second principle, my lord, if the legislature wanted that wherever the MSMEs have been troubled,
Yes.
they ought to be saved. So it's a remedial legislation.
Yes.
So my lord, it is a benevolent legislation. It is a welfare legislation, and it requires my lord to be interpreted benevolently. I mean, 15 judgments under the various enactments, Motor Vehicles Act, my lord, murder is taken as an accident. In any number of instances, I don't want to touch your lordship by reading those judgments. I give a small argument notes with the relevant paragraphs from the judgment. So all this, the welfare legislations has to be interpreted benevolently.
Yes.
The most benevolent interpretation has to be given. Then the principle there is, my lord, the Koti is in verbis. Nulla ambiguitas. If you expositio, conda, verba, fonda, expressa, est. And the legislature, if something is missing, the court can add something more to give effect to the benevolent legislation. And my lord, then my lord, if there is any doubt when it comes to a general benevolent legislation, benigner in sententia, generalibus sui est dubius est preferenda, that means a benevolent interpretation has to be preferred where it is, my lord, a general expression or a doubtful expression ever is used. So this statute has to be interpreted benevolently. I am not on that. For my lord, I don't need a benevolent interpretation, my lord, a strict interpretation. A literal interpretation is good enough for me. And therefore, my lord, I take your lordship to the notification. The notification does not prevent recovery forever. No. It has created a collegium of banks' own offices, so that the bank's interest is primarily taken care of. And my lord, the notification, I take your lordship to the notification. Yes. I page 70, at page 70, my lord, I'm taxing your lordship time because this is involving a rise of 1,000 people. One erroneous judgment is cited elsewhere and based on it, a wrong, my lord, pyramid is built on erroneous foundation. And my lord, subpart fundamental, call it topos, it has to fall down, it will fall down. And I take your lordship to page 71, paragraph 3. Composition of committee. Page 71, paragraph 3. Page paragraph 3. Composition of committee for stress micro, small and medium enterprise. The constitution of the committee shall be as under. A regional, sorry, my lord, page 71.
Now,
page 71, paragraph 3. Composition of the committee for stress micro, small and medium enterprise. The constitution of the committee shall be as under. The regional or zonal head of the bank, who shall be the chairperson of the committee. Then B, officer in charge of the micro, small and medium enterprise of the credit department of the bank at the regional or zonal level, who shall be the member convener of the committee. One independent external expert with the micro expertise in micro, small and medium enterprises later matters to be nominated by the bank. One representative of the concerned state government concerned. They don't use the proper English. One representative from the state government concerned. Yes. Now, this is a committee. This committee, an application has to be made to the committee, and the responsibility to the constitute the committee has been placed on the board of directors. I only take your lordship for the second to paragraph 2, page 70. Paragraph 2, page 70. Committee for stress micro, small and medium enterprises. Subject to the regulations prescribed by the Reserve Bank of India for this framework, all banks shall constitute one or more committees at such a location as may be considered necessary by the board of directors of such bank to provide reasonable access to all eligible micro, etc., etc. So the responsibility is cast on the board of directors. And the South Indian Bank has considered not a single committee. If my friend can give a reference to any one committee, I withdraw my statement. Not a single committee has ever been constituted until this notification and this act has been gone to the base box. They complete disregard to the statutory provision. That is my first prayer was that. Whereas statutory authority and bank also exercising a public function. It is a state, not by it is the nature of its ownership or proprietorship, but because of the function. And they did not constitute any committee. And therefore, my lord, now, under the scheme, under paragraph 4, what is contemplated is a judicial function, a record which is of a judicial nature. They have to make an application. If I don't cooperate, assume that I don't cooperate, I may take your lordship to paragraph 72, page 72, paragraph 6. Page 72, paragraph 6.
yes.
Where an application is filed by a bank, and admitted by the committee. The committee shall notify the concerned enterprise about such application within the time limit prescribed by the Reserve Bank and require the enterprise to respond to the application or make representation before the committee and discloses the details of all its liabilities, including liabilities owed to the state or central government and unsecured creditors, if any, within 15 working days of receipt of such notice. Provided that if the enterprise does not respond to the above within the above period, the committee may proceed as parte. So the whole scheme is the burden is on them. And my lord, what has been lost sight of is that there is no obligation for me to apply at all. That is entirely optional. I take your lordship to page 70, para 2. Page 70, para 2. Identification by the enterprise. Any micro, small or medium enterprise may voluntarily initiate proceedings under this framework if the enterprise reasonably apprehends failure of its business or his inability or likely inability to pay debts. So if I do anticipate, I do apprehend my failure, I can. And in this case, para 3 applies.
Yes.
Application for initiation of the proceeding under this framework shall be verified by an affidavit of the authorized person. Then now if I apply, Sapara 4, when such a request is received by the lender, the account should be processed as SMA 0, and the committee under this framework should be formed immediately. So this is entirely optional, and not a single MSME in this country has done it because they were not aware of it. Now, on the contrary, may take your lordship to para 1. It is mandatory, and that is what Supreme Court has said in Pronet. I don't require any Pronet. I have when the statute is clear, the first principle or interpretation, absolute sentential, expository, not literal interpretation. When the Parliament has employed certain words which is capable of definite meaning, and the word meaning does not create any impertinency or inconsistency or any difficulty of comprehension, then my lord, the duty of the court is to give effect to it. Therefore, my lord, identification by banks or creditors before a loan account of a micro, small and medium enterprise turns into a non-performing asset. This has to be done before my account turns into non-performing asset. Banks or creditors are required to identify incipient stress. This identification is before the SMA 0 stage, and that is what the notification of the Reserve Bank of India has taken care of. I take your lordship to the notification of the Reserve Bank of India at page. That is SMA 0. Yes, my lord, got it. Yes. Your lordship will find it at page number 10. At 112. Page number 112. Illustrated list of signs of stress for categorizing an account as SMA 0. Delay 90 days or more submission of statement. I'm not reading full actual sales, etc. I'm reading something which easily can be understood by layman like us. 3. Return of 3 or more checks. Then my lord, yes. 5. Third request for extension of either creation or perfection of securities, etc. Then 6. Increase in the frequency of overdrafts in current accounts. Borrower reporting stress in the business and financials. Promoter pledging, selling their shares in the borrower company, etc., etc. If any of these things, these are illustrative lists, the banker is required to identify it, because the entire banking system is highly computerized or technology driven, and they can identify it. And they were duty bound to do it. They did not do it. But in case they do it, in case they are not able to identify the incipient stress, at least when I take your lordship to page 72, para 1, then SMA 1, the middle part, my lord. Middle part, SMA 1, page 71, middle part, SMA 1. Principal or interest payment overdue within 31 to 60 days. SMA 0 requires principal or interest payment not overdue more than 30 days. But the account showing signs of incipient stress. Even when my account has not been irregular for more than 31 days, still, if it's showing signs of incipient stress, SMA account has to be created. I'm not complaining about that. I'm only complaining about that when they realize that my account has been in default for SMA 1, SMA 2, because they noticed that my account has been in default for 90 days, and therefore they invoke sufficing. When this happens, there's a default. When a default occurs, immediately a committee has to be constituted. Make an application to the committee. Then the committee will decide what kind of resolution of stress to be adopted, whether the rectification or whether restructuring. These are all technical terms, you don't have to go into Manoj. And finally at 73, page 73.3. Bottom recovery. Once the first two options, A and B, above are seen not feasible, due recovery process may be resorted to. The committee may decide the best recovery process to be followed, etc., etc. So, therefore, this enactment, a benevolent legislation, which steps into and which it coexists with other legislation. It may not be. It is a later law, but I am not saying that it overrides the SME Act or any other enactment, RDDF Act or any other enactment. It only says, yes, the Parliament in its wisdom felt that MSMEs has to be saved. So it casts a burden on the banks to identify incipient stress, constitute a committee, make an effort for resolution of stress, and if it is not possible, allow liquidation, recovery and liquidation. This is a simple notification. It offers no difficulty of any kind of comprehension. And at the greatest respect, all these difficulties were created by the courts in giving understanding this simple provision. And the first came from the Kerala High Court in the case of Abdul Nas, which your lordships have referred to the judgment, the review petition. Yes, sir. May I take your lordship to the review petition? Abdul Nasir, before that, Kodak Mahindra, my lord, Kodak Mahindra. From page 54 onwards, Kodak Mahindra, my lord, the Kodak Mahindra, the dispute was between two creditors. I take your lordship to the Surface Act, section 26E. Section 26E. Yes. Section 26E. The lordship will find the same book, provisions at the bottom, substituted by Act number 44 of 2016. With effect from 1/9/2016. Then, my lord, 26E. Priority to secure creditors. Notwithstanding anything contained in any other law for the time being in force, after the registration of security interest, the debts due to any secured creditor shall be paid in priority over all other debts and all revenues, taxes, cess and other ways payable to the central government or state government or local authority. Explanation. For this purpose of this section, it is hereby clarified that on or after the commencement of the insolvency, bankruptcy court, etc., in cases where insolvency or bankruptcy proceedings are pending in respect of secured assets, or the priority to secure creditors in payment of the debt shall be subject to provision of the code. Therefore, my lord, prior to this enactment, this amendment, MSMEs had a priority over secured creditors.
Yes.
And my lord, you may take your lordship to chapter 5 of the MSME Act. May I take your lordship to the section 24, which is on page 14 of the MSME Act. Your Lordship said MSME Act, no?
Yes.
Page 14. Section 24. Overriding effect. The provisions of sections 15 to 23 shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. And this section is a benevolent section. May take your Lordship to just for academic interest to section 16. The date from at page 11, section 16, date from which the rate of interest is payable. And my lord, the MSME, the amount due to MSMEs has to be paid 3 times the bank interest. I'm reading a little bit last sentence of it. Yes. Be liable to pay in compound interest with the monthly rest to the from the date immediately following the date agreed upon at 3 times of the bank rate notified by the said bank. So MSME will get 18% interest. So the legislation in the eye of the legislature, my lord, the MSMEs have a great priority given over financial creditors. So in 2016, the Parliament in its wisdom felt, yes, that is, secured creditors shall have priority even above MSMEs.
Yes.
Then, my lord, the question is whether this is a special MSME Act, a special law. This is a general law which will prevail over etc. is another question, but it is not relevant for our case. Therefore, my lord, now this was the issue in the case of Kotak Mahindra was the MSME as a secured creditor proceeded against the property of somebody to whom it has supplied goods, who is also a debtor of a bank. The bank proceeded under the Surface Act. The MSME proceeded under the MSME Act and got an award. And MSME sought to enforce this through the revenue recovery mechanism of the Madhya Pradesh state machinery, state government. And then the Supreme Court, the Madhya Pradesh High Court said MSME, between the MSME as a creditor and the bank as a secured creditor, the rights of the MSME will prevail. The Supreme Court reversed it. And in reversing, it relied on 26E and said because of 26E, the banks will have a priority between another creditor named the MSME. So that was the issue in Kotak Mahindra. It has nothing to do with the case of a borrower and a bank. It is absolutely no connection. Absolutely no connection. And a judgment of this court in what is the name? Yes, this Kotak Mahindra, I take your lordship to page 54 of the Judge of Lordship's judgment. Page 54, para 20. I am not reading, my lord, your lordship have dealt with it. Page 20, 21.
Yes.
Then, my lord, 22, up to page, yes, up to page 60, yes. Up to page 60, it is all the discussion about the. So this is completely, my lord, if I am a judge, I will make more mistakes. So my lord, to err is human, and I would say to my lord that normally the lawyers, my lord, often shall have a job to allow a review. My lord, it is actually falling on earth is a greater, hitting you is a greater possibility, probability than a review ever being allowed. But it happened 2 days before. The division bench of the Bombay High Court, Justice Azad, Justice Azad, the better Justice Justice Azade and Justice Bharti Dagre allowed my review petition. The controversy therein was the single bench Justice Purniwala said the bar under section 63 of the IBC etc. Takes away the jurisdiction of the civil court. The division bench affirmed it. I went in an SLP. SLP was dismissed independently. In fact, I had filed a review petition earlier, probably in contemplation of the dismissal of the SLP because all SLPs have dismissed. Because the courts are in a great stress. There were so many, the number of SLPs maybe 60,000. there are only 17 courtrooms, courts, 17,000 hours in a year. So it is impossible for the court to really manage the inflow. So many cases it leads to dismissal. So therefore, in anticipation that I filed a review petition, the review petition was heard and review petition was allowed. And in earlier instance also, in the case of Manisha Mehta, she is the leader of the MSME Association, that by judgment dated 11/1/2024, a bench of Justice Palabawala dismissed our plea, holding that this notification is not mandatory and it is only a directory. And that was challenged before the Supreme Court. The first person to challenge was Manisha. It was dismissed by Chief Justice Khanna and Justice Divanga Dattu. Then, my lord, I filed a review petition after that. Then that review petition was dismissed. Then by judgment dated 15/7/2024, a bench of Justice Suryakant and Justice I forgot, yes, allowed my SLP and remanded the bank. This is the judgment of Justice Chief Justice Alok Adhade and Bharti Dante. This was review. Therefore, this judgment was reviewed last week.
Yes.
And in fact, I recovered Justice Margis Kalyan, and there it was on a fax. And a factual error, a judgment need not be reviewed because the court is free to err. But His Lordship Justice Margis Kalyan was pleased to review a order which was factually incorrect but otherwise not reviewable. Because the court is free to err within fact.
Yes.
Because that is the concern meaning of the word prestidigate facit ex albo nigrum. A judicial decision on facts can make what was white black, ex nigro album, what was black white, ex recto curvum, what was straight true, ex curvo recto, what was curved straight. This is the good players words. Most of people are small organized form. All these quotations, the Latin maxims were used now, which has been used by Justice Nariman in his book, in his judgment. Yes, that is mostly come from Ulpian. There are 5 great lawyers, Ulpian, Fabini, and Paulos, Agostinos, Gaius. Yes, may I take your lordship to Justice Nariman's. I'm sorry, my lord, I'm a little disorganized. Yes. Don't worry.
Yes.
I the lordship may find a page. Page 239. Lordship got me page 239. Yes. Roma locuta est, casa finita est. Well, there's another story behind it. Ulpian and all said, out of necessity, in the public interest, an erroneous decision has to be given effect. But later, the Pope said that Pope is infallible because he was protected from the Holy Spirit from committing error. And the Pope was the supreme judicial tribunal. He had all powers of temporal, spiritual, all matters. And therefore this maxim, Justificata pro veritata accipiter, has changed into Roma locuta est, casa venita est. Rome has spoken, the case is closed. Rome spoke through her laws. One of the pillars of the Roman law is contained in the maxim, Justificata pro veritate accipiter. A thing adjudicated is received as truth. That is, judicium semper pro veritate accipitum. Semper means always. Judicium semper veritatem is true. Accipitum is accepted. Judicium semper pro veritate accipitum. Or judicata pro veritate accipitum. This maximum Roman law is based upon two other fundamental maxims of Roman law, namely, Interesto Republico Uxit Finis Litium. It is in the interest of the Republic that shall be finality of litigation. And namo dabet bisvexari pro uno et idam cosa. No man shall be vexed on the same question more than once. Yes, indeed, that is the maxim is almost universal in all ancient laws, etc., etc. Now the point I am canvassing here, my lord, is, my lord, the first principle is the judicata facit. Ex argo
Not wait here. Then come up to
a court can err on facts, but a court can never bind a parties by its erroneous decision on law. And the celebrated judgment in this aspect is Ambili. Yes. The facts in Amdile's case were not. The facts in Amdile's case was that the 5-judge constitution went to the Supreme Court. They made a request to the Chief Justice of the Bombay High Court to constitute dedicate or appoint a judge to hear the conduct a trial under the Prevention of Corruption Act. Andile challenged that 5-judge judgment by petition was rejected. Andile did not give up hope. Andile raised the issue of quantum jurisdiction before the trial court, which is a High Court judge. That was rejected. SLP petition was filed, rejected. SLP was filed, admitted, and then the matter was referred to by a 7-judge constitutional bench. And by a ratio of 6:1, except regularly descending, it was held that even the Supreme Court, the highest court of the land, cannot by erroneous decision confer a jurisdiction upon it, and where its decisions are in conflict with the statute, that statute will prevail. And whatever has been done, where a judgment is in conflict with a statute, it is ordained null and void. So my contentions here in my case is on the twin grounds, or on the 3 grounds. First is that, my lord, the notification is mandatory.
yes.
And where it has been violated, the courts are duty bound, my lord, to enforce it. A writ of certiorari will lie.
Yes.
And the only question to be asked is, did you constitute a committee? Did you act in conformity with the notification?
Yes.
This aspect has not been considered at all in the judgment.
Yes.
I filed a case. I filed a repetition here that the 2 companies, the 2 entities, 2 petitioners were here, 2 petitions, 2 appeals. The both entities came on occasion earlier. And in those cases, nothing was decided. On those cases, this is Devan Daman only relegated me to the civil court. So I continue in the afternoon.
You can continue.
Okay.
Normally we raise after 1 o'clock. Normally we continue after 1 o'clock for some more time.
Okay. Yeah, I have a little problem, but actually I had removed there was an inspection entire we removed. Actually I am in pain. If your lordship can get me on Monday, I'll be grateful. I am actually not well.
Monday another matter is specifically.
No,
Monday another matter is specifically.
And
the lawyer from outside is.
The whole problem was that I was taking Clopilet. So then therefore it was good to reading.
Heard arguments of the land council for the petitioner in part. The land council seeks a short adjournment.
On medical grounds, medical grounds.
Short adjournment on short adjournment. Just on Tuesday.
Your lordship will be pleased to keep it on when, Whatever date, my lord, your lordship
Tuesday or Thursday. Either Tuesday
then
or
your
Thursday.
lordship be pleased to keep it on, my lord, next Friday, my lord, next Friday.
The Land Council seeks posting on next Friday for further arguments.
Yes, by then I will be fine.
Yes.
Grateful, I'm thankful to your lordship for your lordship's kindness.
No. Don't. We are not expecting such submissions here because we are repeatedly telling lawyers that such submissions are unnecessary here because.
Greatly obliged.
Yes.
Greatly.
ബാക്കിയുള്ളവരോട് വെയിറ്റ് ചെയ്യണ്ടെന്ന് പറഞ്ഞു. We continue at 2 o'clock.